Okay. I too am overwhelmed by Eric, and I'm just so glad he is a great lawyer and works in our community. I want to address the personal aspects of estate planning because though we're talking about a legal structure, we're talking about something that we want to honor ourselves, honor our assets, and to honor our relationships. So when I think about having this conversation with my family, and I recommend this to all of you, probably the best way to start the conversation is with Chardonnay. The second thing I think that's really important is to, before you go to see an estate planning attorney, to spend some time with yourself, with your spouse, getting very clear about what your intention is when you go to do this estate plan. I have worked with people who were grandparents and they wanted to do their estate plan on a certain day because they realized that they had just had it with that one grandchild that still hadn't written them a thank you note for their Christmas present. They were then going to use their estate plan as a weapon. And I don't think that's okay. I think we need to spend time meditating, praying, walking the beach, doing whatever we need to do to get really clear about getting everything in order, updated to our present life circumstances, passing our assets on without a hook from the grave, and making sure that we're also passing on a legacy of love, because isn't that really what it's all about? It was interesting when my grandmother was dying and we sat down with her lawyer to look at a will that she had done many years before. I couldn't believe she had done this and she had forgotten. But she had been a very staunch Republican. She lived in Southern California, and for some reason she put a statement in her will that if Sherry should happen to marry a Democrat, and boy did I show her. She also happened to put a statement in there because my mother had died of alcoholism. She said if either Sherry or her brother Brad should become an addict of any kind, they are to give up their part of my estate to the other one. And when she put that in, she was a very sad, wounded woman who had lost her only child to alcoholism. So the way to deal with her pain was to go off and do an estate plan that would speak to her sadness. But time went on and she had forgotten that she had put that provision in there. And the beauty of when she was dying is that we got to sit down and look at those provisions. And nobody was more stunned than she was. So I ask you please to be really clear about what your intention is with your estate plan. You want it legal. You want all your assets up to date. You want designated beneficiaries. You want contingent beneficiaries if something happens to the person that you're initially leaving your asset to. But you really also want it loving. You want it clear, you want it legal, and you want it kind. That's something I believe very strongly about. So first is, how clear is your intention about the estate plan that you're doing? And people say, well, I don't have enough money to do an estate plan. And I say, if you have a checking account and a bicycle, and you feel very strongly about who you want to get those things, please, please, please do a will, for sure. Secondly, I think we all deserve to have a trustworthy attorney. You wouldn't go out and buy the first car you're going to drive. Why in the world would you choose the first attorney you're going to meet with? I think that we should all meet with 2 or 3 of them, call ahead, see about getting an initial interview, see if you can come in and meet with that person for free for 15 or 20 minutes. If they're going to charge you a little bit, I think it's worth it. So that you're deciding who it is that's going to help you with this very major event in your life. I think husbands and wives should go together because you don't know which one is going to die first or become incapacitated. And it might be his golfing partner that he's chosen to be your estate planning attorney, but it's not yours. You deserve to work with people with whom you're compatible, especially your estate planning attorney. If you already have an estate planning attorney and your husband has died and you are the widow and you find that this person is impatient, sarcastic, and not good at explaining things, You have every right to change attorneys. People with demeaning, sarcastic personalities do not get better with time. And I feel really strongly about that. If you're going to be paying this person so much money, even with the financial saving tips, you're still paying that person a lot of money to create an estate plan for you. You deserve to work with somebody with whom you're compatible. So interview 2 or 3 of them, find out how comfortable you are with this person. I always want to get to know their paralegal. I also want to know that if they're going to retire or they should become sick, who's their backup? I want to know their backup before something happens. With their permission, and I don't know if you'd allow this, Eric, but I will go with the client and I will ask that attorney if I can tape the session, because I don't want to go home and think, did he say 6 months or 6 years or $6,000 or $6 million? So with the attorney's permission, I will tape the session so that I can play it back and not have to call him for another $100. Some attorneys will do estate plans by the hour, some will do it by a package. You can negotiate that. But your job is, you do not, as the client, have to know what an attorney knows. They went to school for a long time, they studied hard. But you do have to trust your instincts and stay on top and in touch. And I think it's also really important when you find the right attorney or trust officer that you introduce this person after you've completed your estate plan, introduce them to your family before you're in a crisis. This person should become a part of your family. Your estate plan is a living, breathing entity that is going to be cared for and fed every year. Why not have the person that's attached to that become part of your life? Introduce them to your kids. Bring out the champagne. Have an annual life planning day. Anything you can do to humanize this very legal process is a gift in terms of your own well-being, and certainly a gift in honoring your relationships. And each of us has the right to do that. So I urge you to. And remember, when you go to see an estate planning attorney, there are no stupid questions. There may be stupid answers, but there are no stupid questions.
Thank you, Sharon. I appreciate it. Yeah. I'll give you just a little, personal story. When my wife and I put our estate plan together, it was very important for me to find an attorney that she got along with really well. So we did interview multiple attorneys and really found somebody that we were both comfortable with. And then the second part of it was actually really interesting because it became a conversation in our home. So I have 3 daughters, 12, 9, and 4, and we shared with them, if we died, these are the people that would be your guardians. This is, just starting that conversation, and who better to have that conversation than us with our children. So I really appreciate you sharing that about just the comfort with the attorney. This time I want to jump up back to Eric. He's already covered a lot of these different documents, but if you wouldn't mind just maybe spending 1 or 2 minutes on each one of these and maybe highlight a few points that you want to share on each of these important documents, that'd be great.
Where are we going to?
Where are you?
Okay. 46.
Estate planning documents. There we go.
Okay. Well, we may not match up with the slides exactly, but bear with me. There's 3 types of wills in California. I just want to make you aware of this because a lot of people don't know this. You can have attorney-drafted wills, which are probably the safest way to go, and I don't say that just because I'm an attorney and I do it for a living. I've seen the other kinds, and they don't always turn out very well. There is something called a statutory will, which the State Bar of California has available on their website. And anybody can go there, download it, print it out, fill it in. It's a fill in the blanks. It's not hard to do, but it's limited in terms of the scope of what it can cover. If it's not right for everybody, but if you happen to fall in their little niche of people that it works for, it's a good way to go. I recommend it. And then there's a third kind of will in California called a holographic will. You've probably heard of these. This is a will that's entirely in your own handwriting and signed by you. They are, believe it or not, legal in this state. Now, that doesn't mean they're recommended. I have seen a lot of things wrong with holographic wills over the years. Just to entertain you a little bit, there was one fellow who wrote out a will of his own and he left everything to mother. That was all it said, just to mother. And it ended up in court because his mother was still living, but so was his wife, whom he affectionately referred to as mother. Okay, so which mother did he leave his estate to? Okay. Got another one that this happened to me, where I ended up with a client who brought this lovely holographic will in, and he had his own business, and he showed me how he divided everything up among various people when he's gone so that different people get part of the business. And I went through and added it up. The numbers didn't look right. It came out to 101%. Anybody see a problem with that? Okay. There's all kinds of things that can go wrong with, holographic wills. I had another lady, give away certain assets. This bank account, that bank account, somebody to take care of her cats, that sort of thing. Well, at the time I met with her, she didn't have either bank account or cats, so, what did she have? Kind of a meaningless piece of paper. I don't like holographic wills. But with a will, you can name an executor, you can name a guardian for your children, you can waive the bond requirement for the executor, which is paid out of your assets, by the way. And you can always change a will. There is such a thing as a codicil to a will. If you want just a little tiny amendment, you can do that, and then you have the will and the codicil together. I want to just touch briefly on the pets mention that I made earlier. You can actually do estate planning for your pets. I don't know if you know that or not, but you can set up a trust for your pet if you want, or you can make sure that your pet goes to a certain person to take care of it. You can leave that person a certain dollar amount if you want them to have money to pay for the care and feeding of the vet bills. It's something you should pay attention to. And the folks who put this together want us to mention the fact that age does not destroy the validity of a will. A valid will signed 50 years ago that hasn't been revoked is still valid when the person passes away.
Can we, mind if we jump up to?
Not at all.
trust?
Go right ahead. Trusts. A trust is basically a legal fiction.
I'm sorry, did you have a question back there?
I just want, Eric, are you saying that if you have a will that's made by a lawyer, that you could write in something?
No, that's not what I'm stating. A holographic will would be entirely in your own handwriting.
Separate, but-
Yeah. If you've got an attorney-drafted will and you want to make changes to it, you could handwrite a codicil to it.
Oh, okay. That would be separate.
It would still be separate, but you want to make sure you're doing it right. So
You don't want to, couldn't write it on the same document.
you don't want to mark up the original will.
Inside.
No, because that could very well invalidate it. I've seen people do that too. Yeah, they cross out one name, write in another. Okay, well, who did that? And how are we going to carry that out? Yeah. Trusts are a little safer, in my opinion, because it's a little more formal. We talked earlier about revocable versus irrevocable trusts. Most revocable living trusts that people do today are exactly that, revocable. You can change them. You can make adjustments as time goes by. You don't have to feel like you're locked into whatever you came up with the first time around. And that's a good thing. There are irrevocable trusts. Most revocable trusts, when the people who created it pass away, become irrevocable upon the death of the creator. But there are some trusts that people make as irrevocable trusts intentionally from the get-go. They usually happen to be very special purpose type of trusts, like an asset protection trust, or a life insurance trust, or a charitable trust, or even a special needs trust for somebody with physical disabilities. Those are all different kinds of irrevocable trusts, but they can be done either way. If you need a trust, it's a great tool for managing things when you're not around to do it anymore. And a lot of us may have younger children who need somebody to kind of keep tabs on things for them and make sure that, you know, they don't blow it all right away when they inherit. And you've got a trustee who is the person who's in charge of managing those assets and making sure that things are invested wisely, that the distributions are made when they're supposed to be made, that the taxes are paid when they're supposed to be paid, and so forth. And again, with the ability on a revocable trust to make amendments, you can change it anytime. It's not hard at all. I encourage you, if you're thinking about a trust, to explore it. There's some state bar handouts on the table out there that are titled, "Do I Need a Living Trust?" And if you're seriously thinking about it, I invite you to take one of those home and look through it, because it will go into more detail about what we're talking about tonight. The last comment I want to make just on this topic is, if you have a will or a trust, like Sherry said, review it periodically. You know, don't just throw it in the drawer and never look at it again. I try to encourage my clients once a year, take your will or trust out, look at it, make sure of two things. Number one, does it still say what you think it says? And I have discovered that many people are flawed in their memories of what they thought they put into that document. And two, is that still what you want? If you can answer both questions yes, put it back in the drawer for another year. Question?
Anything that should not go in the trust?
Oh,
Any assets?
That's an excellent question. Is there anything that should not go in a trust? Yes, there is. The first and foremost thing you don't ever want to put into a trust is your IRA. Why? IRA. IRA account, individual retirement account, okay? Or any other kind of tax-deferred retirement account. With IRAs in particular, the IRS has made it very clear to us that if you change the ownership of the IRA from the IRA owner to a living trust, you have made a taxable distribution of the entire account value, and you're going to be very unhappy. Okay? You don't want to do it that way. We use the beneficiary designations on the IRAs to determine who's going to get it when you're gone. And you can even leave it to the trust if you want, but that's another discussion. Yes, sir.
We're just going to take one question, because we need to move on.
How do you feel about putting your IRAs into, say, a charitable, or like a private foundation as beneficiary?
Well, okay, I'm glad you added that last
Yeah,
phrase,
okay.
as beneficiaries. He's asking about designating a charity or private foundation as beneficiary on an IRA. And I'm all in favor of that. I think that's a great way to go, because if you've got a qualified nonprofit beneficiary of the IRA, and that IRA happens to be subject to income tax when it is distributed, guess what happens when it goes to a nonprofit? They don't pay taxes. So you get more bang for your buck, if you will, by leaving your tax-deferred retirement accounts to qualified charities that you want to support, because they're going to get 100 cents on the dollar. Nobody else will.
So I kind of joked about the library being a possible beneficiary, but all kidding aside, philanthropy becomes an objective for people. As Sherry said, if you're on the beach and you're walking or you're praying and you're thinking about what you want your estate plan to be, there could be a charitable aspect. So one of the things that we're going to get into is maybe some of these sophisticated estate planning tools. So I'm gonna ask Craig to comment on a few of those, some of those advanced estate planning techniques.
Sure, thank you. There are numerous types of advanced estate planning vehicles that can be used for charitable purposes or just to accomplish your own personal goals. Most basic, it would be maybe family gifting. Where probably most of us are aware that you can gift away up to $14,000 a year to any number of individuals, be it family members or friends. that you would like to, and there's no gift impact or gift tax impact with respect to those annual gifts. You can also gift up to that 5.49 figure lifetime gift exclusion. You can do that during your life, and there would not be any sort of federal estate tax impact on those types of gifts. So within your family, you can make those gifts in cash. You can also utilize other types of assets to gift as well. That can be anything from gifting a partial interest in real estate to children or other family members. Benefits there are you're gradually transferring assets to other members in your family. You're reducing the value of your estate by doing that. If taxes are a potential issue, that can be a very effective tool. We're talking about charitable gifts. Certainly you can make gifts to those organizations that you care about and you want to support by way of cash, writing a check, or securities, stocks that you may want to gift. You can also make provisions in your will or your trust for making gifts to the charity of your choice. There are other more sophisticated vehicles. One is called a charitable remainder unit trust. And the nice thing about what we refer to as a CRT, charitable remainder trust, is basically it allows you to create an irrevocable trust, as Eric was talking about. You place assets into this trust, and most commonly you're using an asset that's highly appreciated. Maybe it's stock, maybe it's property. You make this gift into the charitable remainder trust. You may get a tax deduction for making that gift. The asset can be sold once it's in the charitable remainder trust by the trustee. And one of the benefits by selling it in the trust is there is no capital gain tax or minimal capital gain tax on the sale of that asset. So if you have a piece of property that you paid $42,000 for and you sell it for $500,000, or it's sold in the trust for $500,000, you have a substantial gain there that you're not paying, the trust is not paying any capital gain tax on. So there's that type of tax avoidance or tax benefit of using a charitable remainder trust, but it gets better from there. By establishing the trust, you also can get a lifetime income based upon probably 5%, 6% of the market value of that trust on an annual basis for your lifetime, the lifetime of your spouse, if you so choose. And then upon your passing, the assets that remain in that trust go to your favorite charity. So it's a great planning vehicle from a standpoint of potentially turning assets that are not producing income for you into a trust that is generating income for you on a monthly or annual basis. You have the tax benefits, and then ultimately it's going to go to the charity. So that's just one example of a more advanced or involved type of charitable planning vehicle that I'm sure that Eric would be very happy to discuss, and I know that Ralph and Inga here at the library are very familiar with planning vehicles as well.
Thank you, Craig. That's great. Eric, do you have something to add?
Well, there's something that's not on this slide that should be up here, and that's special needs trusts. If you have somebody in your family who is on SSI, that's Supplemental Security Income, or Medi-Cal, which is, you know, the healthcare insurance for the indigent, those benefits that they receive are conditioned upon certain income and asset limitations that they have. And if you leave a person who's on SSI or Medi-Cal an outright bequest as an inheritance, you probably have just taken away their government benefits. because they're no longer eligible for them. There is an alternative that you can use, which is called a special needs trust. And that can be structured in such a way as to supplement the benefits that the person's receiving without making them ineligible for them. So that's about all I'm going to say about that right now. But if it's a topic that's of interest to you and you have questions, please, I don't mind if you give me a call.
If I could just echo agreement there, that the Special Needs Trust, I've been involved in administration of several of those types of vehicles, and it's just a great way to not only, provide care for a beneficiary, but it's a way to very effectively enhance their life. And there are, as Eric would tell you, there are certain restrictions involved. You don't want to jeopardize those governmental benefits, but when it's done properly, it can be such an effective way to enhance a beneficiary's life while still providing that underlying foundation provided through the other benefits. Thank you for mentioning that.
Thank you, Craig. So I would just say we're gonna hold that question if you don't mind. The goal tonight is really to take all these very complex estate planning issues and make it a little bit more simple. So the next slide here is really just some helpful steps. So if you went through that quiz and you had a pretty low number, this is a great starting point just to see what those steps would look like for you to improve that score. So we have a 6-step process. If you were here last week, this process is very similar to the financial planning piece. The first part is kind of like what Sherry was saying. It's really trying to figure out what you're trying to do. If you have assets, if you have children, if you have philanthropic, this is really understanding what your goals are with your estate. If you're no longer here to administer that. Next one would be gathering all of that data. So as you're interviewing attorneys or professionals, this is your opportunity to start gathering some of those documents to put together, retirement plans, looking at the beneficiaries, things like that. The next step is looking at your situation, analyzing it, maybe meeting with that estate planning attorney. And then 4th step would be strategizing. So looking at your plan and figuring out the proper way to maneuver that to achieve what you're trying to do. And then implementing it. That's the most important part is, you can do something, but it's not really done. And Eric, you probably have seen this before. I've seen people that have sizable estates that they've got the trust done, but they didn't bother taking that extra step and going and funding the trust by changing title on all those properties. And you see it time and time again, but most attorneys, a good one, will help you in that process as well in implementing it. And then the last step is really just tracking and monitoring your process. So checking it out every year, having that family meetings, maybe having those conversations with your kids. So these steps right here are, they're not too complex. They make it a little bit more achievable. So I would encourage everyone to write that down. We do have this in greater detail in your estate planning organizer. It starts on page 15, and then it goes on page 52 to 53 with a handy checklist there.
Those are downloadable.
Those are downloadable. So
200 pages.
the gift just keeps on giving. So we're gonna move on to some helpful tips. So those 6 steps is a useful tip, but let's get a little bit more practical, specific. So I'm gonna reach out to Sherry and have her just share a few maybe cost savings tips that may already be available to us that we don't know about. Before we get into that, do you have a question, ma'am?
I just keep wondering, if you have done all of this, you have all these documents, and you pass away, and your heirs, what happens then? They can't just take these documents and take your things, they have to go to court. What do they have to do to get?
Well, I'll kind of answer that. That may be a specific question because I think it really depends on what documents you already have in place. I think Eric has really stressed that a living trust will essentially avoid probate for the most part.
But if you have a trust, you have a will,
Again, it depends. That's my favorite answer, everyone. Depends.
They can't just
If
start
your
writing.
house is titled into the trust,
How
then
do
it's
they
gonna be
get-
easier. How do they get them? Any comments on that?
Tell someone,
Yeah.
and we'll get into that in a couple of minutes. I think that it's important to, I think, have as much communication as possible with your beneficiaries and family members. I think it's also really important that someone would know where all of your documents are.
Well, I was once named an heir to somebody. I had to go to court
Mm-hmm.
to get whatever it was years ago, so I could start writing checks. I couldn't just
Mm-hmm.
do it without.
Okay.
Yeah.
I appreciate your comments, ma'am. If you want to stick around, I'm sure one of the attorneys or Eric can maybe spend a few minutes with you. But I would like to get Sherry's comments and some of those practical tips that we can apply.